I've been asked recently on several occasions to give a summary of COVID and its impact on families and family law. What's transpired, court protocols, new trends, an update on court cases. And obviously this is a topic that we can go on at length for, but for the purposes of our interview and for a short summary, I believe it could be summarized in 4 different areas. Number one, this approach that for some reason COVID brought a spike to divorce cases in the state of New York. I've actually looked into that, and we've looked into the research, and there is no discernible evidence that any of this transpired. And in my practice, it has been as it was before, with the amount of cases going through this office and through the court system. Secondly, the early shutdown of the courts and what happened in March of 2020. The court responsibly shut down immediately upon the pandemic hitting the United States. And so what happened is there was an early disruption of court cases and the accessibility of judges to be dealing with families. This is an important consequence. To its credit, the court rebounded in a new way, and I'll talk about that in a few minutes. But as far as the early cases, you recall we had this tremendous amount of cases where parents were trying to limit the accessibility of the other parent to have parenting time based on COVID and its potential exposure to children and to themselves. And as you recall, the courts dealt with it in the following way. Absent a specific and identifiable expressed safety or healthy risk, the courts were never going to allow COVID to defeat the parents' rights to accessibility to their children and to parenting time. Third point, the evolution of the court system. Previously and generally, all family court appearances, Supreme Court appearances required the parties and their attorneys to appear at every court conference. Well, COVID did away with that. And fast forwarding to now, what we have is basically all court appearances are generally now virtual, where the parties and litigants do have to appear, but virtually. Wow. As far as other areas of the law, this was necessary, and it could be stated that it's probably unnecessary for the litigants to appear and the attorneys to appear at every court conference as they try to move the case along. It could be argued, however, that in family law, that is not the case. We're talking about the future of families, their finances, their emotions, and their children, a different level than in other cases. But there are pros and cons. What are the pros? For the client, reduced attorney's bills, because now they're only paying for the time that the attorney is actually speaking to the judge, as opposed to all the waiting time and travel time that an attorney would take to get to that court conference. Secondly, that half hour or hour that the attorney has with the judge is basically the same amount of time that the attorney would have whether it was virtual or in person. The opposing argument, though, is a very interesting argument, and that is going to court, the presence in court, and the pressure that a judge and other individual would put on the parties and litigants to communicate and sit down cannot be understated. Judges would sometimes force the litigants and the attorneys into a room to resolve, if not the entire case, but several points so that they can make it easier towards moving the case along. And I think that's an important consideration. In fact, I've been involved in many court cases where the judge would not allow you to leave the courthouse until certain things were resolved, or you would have to have a hearing. And that's, again, very important. And so it could be argued without that kind of pressure and that presence of the judge, that the urgency of the parents and the case is lost, and sadly, that the angst of the parents is prolonged. Final point, cases. What have been the case updates? You'll recall that we talked initially that it was about accessibility and the early onset of COVID. Now, the issue is vaccination. And perhaps the best way to summarize what is the status of these vaccination cases is to review a few cases which were submitted within the last few months by well-written, well-respected judges. In a New York County case, the judge took away the parenting time of a parent who refused to get a vaccination concerning his 3-year-old daughter. And the judge's argument was the dangers of voluntarily remaining unvaccinated during this period and the health crisis that it could potentially deal with the child cannot be understated. And so that court dealt with it and basically told and ordered the father in that case to either get vaccinated, get the jab, or be tested, PCR test every week, and a bi-weekly antigen test within 24 hours of parenting time. In Kings County, the court didn't deal with it right away. But there, the parties had already settled their matter. They had joint custody. They had an agreement. They just could not get together, and they were basically diametrically opposed on the issue of vaccination. They couldn't agree on the medical evidence. So the court in that case, because they had an agreement, said that this may involve a substantial change of circumstances requiring a modification of that agreement. You have to know that substantial change and modification, these are key words in the family law world, in the matrimonial world. And so what the judge did, he ordered a hearing. He first wanted to know if this COVID issue had created an unwillingness or inability for the parties to communicate and cooperate on what was the best interest of their child. And secondly, the court also wanted to know, did the father comply with a so-ordered agreement that this judge had signed, where he was obligated to comply with New York City and New York State mandates? Finally, a Monroe County case. There, another case where the parties had joint custody and they had previously agreed to vaccinate their elder daughters, a 17 and a 19-year-old. But here, the father did not want to have his 10 or 11-year-old vaccinated until there were further mandates by the government. And the court there just ordered that the child be vaccinated and that the father would have to comply with that. And the court's reasoning there was the court was not going to wait for the vaccine side effects or efficacy to be scientifically proved. The imminent risk of contracting the disease is too high and the consequences too dire. So that's a perspective on the cases. You can see how the courts were handling it. And aside from a political agenda, let's assume and hope that politics were not a part of this. You could see that the issue of vaccination is an important one, and the rights and obligations will live longer in the court than the pandemic and the virus that brought it on.